celebration of achievement. I need that right now. I really do. And with that, I'm going to share a little information about one of the best organizations that works with our youth. Today we have Kai Wilson, who was named Kansas Youth of the Year winner. Oh, would you go ahead and stand up? Yeah. No, you got to come stand up here and I'll explain, but I want to give some information. The Kansas Alliance of Boys and Girls Clubs is comprised of 12 local organizations currently operating over 70 sites in 19 communities and on military bases in Kansas. Clubs serve youth age 5 through 18, focused on out-of-school programs. And in 20,000 youth. That's awesome. Since 1947, Youth of the Year has been GCA's premier recognition program, celebrating the extraordinary achievements of club members. Each year, one exceptional young person from a Boys and Girls Club is selected to be the National Youth of the Year. Youth of the Year participants embody the values of leadership, service, academic excellence, and healthy lifestyles. Candidates emerge through year-round recognition programs in their local clubs or BGCA affiliated youth centers on U.S. military installations. They progress through state and regional events, culminating in a week-long celebration in Washington, D.C., where one is named the National Youth of the Year. So, again, we recognized, and am I pronouncing your first name right, Kai? That's good for me. Now, here's the fun part for us, is you get to deliver, we'll call it the State of the Kansas Alliance of Boys and Girls Clubs meeting. You're good to go, youngster.
Okay. On the 26th of October, 2006, Rajan Smith was born. Born to her birth mother, who would give birth to well over 8 children. Born to her birth mother, who would give birth to many of the children with different men. Born to her birth mother with a drug addiction, unfit to take care of any of the birth children. Rajan Smith was born to a generation of kids known as crack babies, a generation of kids born with the drug actively in their systems, something that infants should never have to endure. In effect to the birth mother's inability to raise children, Rajan was put into the foster care system. In April of 2008, Rajan Smith was reborn into Kai Wilson as I was adopted into a new family, my real family, which would eventually consist of my mom, dad, older brother, younger brother, and me. My parents have brought me great fortune, but after our grandma, Mama, passed away in 2013, I lost my spark and my purpose. I had a void in the middle of my heart. In 2017, we moved northeast, and a year later, I started middle school. When I started middle school, I was extremely shy, always fitting in with no identity. Nothing could fill the hole that Mama left. But that all changed when I began going to the Boys and Girls Club, and for the first time ever, I created long-term bonds with people, bonds that could not ever be broken. The hole that Mama left was filled. I met Mr. B, a staff who helped me find a side of me that I didn't know existed, a leader. And after that, I got more involved, starting with Torch Club in 7th grade, a program at the Boys and Girls Club based around leadership development. In 2021, I was appointed the president of Keystone, similar to Torch Club, but on a national scale. Now, due to staff changes, it was short-lived, but I realized I was ready to become a leader. I was honored to be a part of something greater than myself, and I was excited for what would come next, which was the summer of 2022, when our Boys and Girls Club launched the Club to Career program, a program dedicated to showing teens the many career opportunities available within Wichita. Exposure to the workforce helped me understand my strengths and weaknesses. As I look into my college career, the Boys and Girls Club has been essential in preparing me for the next level. Life is all about experiences. Saved by my parents and forged by the Boys and Girls Club, I found myself and my purpose. I'm Kai Wilson, proudly adopted, straight-A student, varsity soccer athlete, and a sophomore at Wichita Heights High School. My purpose is to give back to the next generation by helping them find their identity, their own purpose, and their next level, just as the Boys and Girls Club helped me. Through our club, I found the key to success, and that key is to be yourself, because no one else is a better version of you than you are. Thank you.
Yes, Representative Neighbor.
I think when you were introduced today, you're going to study math. Was that?
That's probably the most consistent thing that I'm looking into.
That's a good area. Congratulations.
Thank you so much.
Anyone else? Mr. Representative Wagoner.
Yeah, thanks, Mr. Chairman. So, you have a great, your speech for the Boys and Girls Club. I mean, how much of it you think is just like your club is just like specifically unique, or you just think it's the whole concept of Boys and Girls Club, or I don't know, have you ever thought about it, as to actually how it made such a big difference, to yourself, versus perhaps other kids in the clubs across America?
Well, I know, especially being here, at the state competition recently, I'm seeing all these other people's stories and how it affected them, and I know I'm not the only one. We all have great stories here, and it's really an honor to be able to represent all of them, because I know they worked just as hard as me, and they've had lives even harder than me, so I'm really happy to be up here to represent them today.
Yes, Representative Pickard.
Thank you, Mr. Vice Chair. I'm just so proud of you. I have participated at the Boys and Girls Club on 21st Street in Wichita, where Kai has gone, and it is a great place. It's a great building, great facility, but the people that are there are what make it so awesome, in the programs. So just congratulations, and hang in there and go K-State. Is that right? Was it K-State?
We'll see.
Okay, all right.
That is true wisdom. We'll see. Representative Hoagland.
Howerton,
How?
you're close. A long time ago. Thank you, Mr. Vice Chair. So looking back, if you were to meet someone in your position, 7 years ago, what would be your best piece of advice for them?
Best piece of advice, probably because I know the name of my speech is The Best Version of Me. That's really what it's about. So to be yourself, and don't let anybody try and create some big image of what you should be, to be whoever you think that you are, and to do what you believe that you can be best at.
Anyone else? Representative Howe?
Thank you, Chair, and thank you so much, Kai, for sharing your story. And as I listen to your story, you've had several reasons to work through grief and things that are very sad and very hard. And grief is tough. It's tough for everybody. And I'm so glad that you have found healing and support and pushing ourselves to be the best we can be as individuals is one of the best life goals to have. And I look forward to maybe seeing you back here someday.
Yes.
Thank you,
Representative Humphrey.
Thank you, Mr. Chair. So, Kai, we had the privilege on the House floor of meeting some of the other students that you're up here with for the state competition. Is there anyone else in the audience that you would like to introduce us to? Just one or two people that we should meet also that have been important to you. Anyone else that's here behind you today?
Well, I know definitely my dad is really important. Miss Megan is,
Please
And
stand,
yeah,
please
could we
stand up.
see who?
And Miss Megan, definitely our CEO, definitely making this all possible. Because last year we went through this process at our local club, but we didn't get to finish it. So she was definitely a big part in helping us get through the process this year. It's really helpful. And actually, when I first walked in, I didn't know any of these kids, and I remember the first person that walked up to me and introduced himself to me was Zion. So he was really helpful, me getting to know people, because I was pretty shy besides that. So thanks to him, I kind of got to know people. He kind of introduced me to the group. And I think we could all really be a family. We're all from Kansas, representing each other. So I think it's really big. We're all in this together.
For you. Yeah, thank you so much. And thank you to all of you who've made such a difference.
Yes, Representative Neighbor again.
I think you spoke about loving to play, or you play soccer at a high level. What made you enter soccer, and would you like to look at a college soccer scholarship?
I've actually played soccer since I was 3, so I don't really remember what I got. My parents really got me into athletics when I was younger, so soccer is kind of thing I picked up as my passion ever since I was really young. So that's looking into college for soccer is definitely really important for me.
Very good. Thank you.
Yes, Representative Howerton.
Thank you. Just curious, favorite soccer team?
I'd have to say my soccer team, the Wichita, Kansas Eagles, you know.
Okay.
Clearly, this young man has a diplomatic skill. He's skated on a couple. Anyone else? If not, thank you for your patience for why we were so long on the House floor. But I don't think you will realize how much you uplifted the spirits of this group of people who have been debated some very serious issues. And we congratulate you. Congratulations, sir.
Thank you so much.
You are welcome to stay if you would like. We're going to go on into the rest of our meeting. We have an informational hearing coming up. The first person is going to be Rachel Marsh from Children's Alliance of Kansas. I show that she's here and in person. You have 5 minutes. No, I'm not really kidding.
Vice Chair Johnson, Ranking Member Owsley, and members of the committee, you must have seen the lengthy testimony that I put on your desk and decided that 5 minutes was just going to be enough. My name is Rachel Marsh. I'm with the Children's Alliance of Kansas, and I have put on lengthy testimony on your desk for one reason is that I was late to get it to Carol, and so I apologize for that. But the second reason is this topic that I've been asked to speak on today is complex and relates to very specific standards for guardian ad litems, attorneys, and what the Child in Need of Care Court in Kansas does related to child representation. And I thought it was important that you had the language of those provisions in front of you so that you could refer to them as I was going through my testimony. So Chairwoman Kincannon asked that I kind of share the landscape of what's going on with Counsel for Children in the Kansas Child Welfare System. And I want to it will be pretty straightforward. I just want to provide you with that basic information. So as to start the testimony, and then I'll work down to the issue of whether there would be reasons to change our system and what the benefits could be seen. I want to start out by saying very clearly, for anyone who isn't really familiar, all children that enter foster care in Kansas are appointed a guardian ad litem, and all guardian ad litems in Kansas are attorneys. And because of that, all guardian ad litems in Kansas operate under the Code of Professional Responsibility for attorneys. Just for the purpose of answering the question that does come up frequently, what is the role of CASA? CASA is not an attorney or not required to be an attorney and does not play the role of the guardian ad litem in Kansas. I point all these things out because every state does it a little bit differently, and so this is what happens in Kansas. I want to start out by saying that my work in Kansas has been in child welfare courts, and as an attorney and as a social worker. And so I wear a lot of different hats, or I have worn a lot of different hats over the years. And it's caused me to think, I don't know the ability to not be a social worker and an attorney, but when you are, you spend every day wondering, what hat am I wearing? Because you want to make sure that you're following the right rule for your job. And so I've thought a lot about the role of guardian ad litem and the role of counsel for children and how they're different and how they're the same. I want to start out just the selected language from the Kansas Child in Need of Care Code shows that the court will appoint an attorney, guardian ad litem, for a child who shall conduct an independent investigation of the facts in the case and shall represent the interests of the child, the best interests of the child. It does not say will represent the child, and that's what this conversation will be getting into. If there is a difference between what the child's best interests are and what the child desires the attorney to advocate for, the guardian ad litem is required to simply advise the court of that disagreement. There is a possibility in Kansas law that a court can appoint a second attorney. I have almost never seen that done in my own practice, so it's a theoretical possibility more than a practical consideration. If a guardian ad litem is appointed, then what does a guardian ad litem do? And then we move to the next page of my testimony, Supreme Court Rule 110A. A guardian ad litem must comply with the following standards. They must conduct an independent investigation, reviewing all the documents and records that might come out in a child in need of care case. They have continuing investigation and ongoing contact with the child. The next obligation is that they are to determine the best interests of the child in their own judgment. They shall consider the factors of the child's age, the child's level of maturity, the child's relationships, but essentially the obligation of the guardian ad litem by Supreme Court rule and by statute is to substitute their opinion about what the child needs for what the child might actually want for themselves. So then the next obligation for guardian ad litem is to represent the child in court, just like you see on TV, and explain to the child what's happening with court proceedings. And finally, the guardian ad litem must recommend services for the child and the child's family as part of their job. Number 6D is really the issue where we get into the difference between the best interests of the child and the child's wishes. And again, just like the SYNC code requires, the Supreme Court rule says the guardian ad litem must simply inform the court of a disagreement if the guardian ad litem's recommendation for the best interest of the child is different than what the child would want in a particular conversation. So that all sounds great. And I think when we think of guardian ad litems, we think of people who are working in the field every day to try to make children's lives better by being in a protector role. I think it is helpful to stop and ponder what would be different for children if we had an attorney standard. And so I've gathered the Code of Professional Conduct, and I'm sorry, that's probably one of the most tedious testimonies I'll give this session. I've gathered some of those provisions so that you can see how an attorney's role is the same or different than a guardian ad litem's role. So first of all, an attorney has to be competent, and that means having the requisite knowledge, skill, thoroughness, and preparation. And specifically, an attorney to represent a client is supposed to inquire into and analyze the factual and legal elements of the case, and includes adequate preparation for court. So there's a lot of similarities there between doing that independent investigation of a guardian ad litem if you're really engaging. The second rule is that the scope of a lawyer, as opposed to a guardian ad litem, is that you abide by the client's decisions concerning the reasons for the representation. And the client has a great deal of say. However, immediately following that rule in the comments to the Code of Professional Responsibility, it says that in a case where the client is suffering diminished capacity, the lawyer's duty to abide by the client's decisions is to be guided by a special section of the code that specifically references being a minor child. So we already have a provision in our Code of Professional Responsibility where an attorney can represent a child in a unique way, even if they weren't a guardian ad litem. Rule 1.3 diligence, a lawyer shall act with reasonable diligence, with commitment and dedication to the interests of the client. The workload shall be controlled so that each matter can be handled adequately. And a client's interests can often be adversely affected by the passage of time, which is kind of underpinning the importance they may even make in the comment about lawyers about the challenges created for clients of procrastination and not being diligent. I want to pause there. When we think about children in need of care and what they have lost and what their rights are at stake, there is possibly nothing more than your family. And I believe that there is a Supreme Court case that says your losing your family is akin to the death penalty for the familial relation. So it has the highest standard of concern. So an attorney has significant duties of diligence if they were to represent a child in the Kansas Child in Need of Care Code because of the importance of the interest that the child has. Rule 1.4, communication. Attorneys are supposed to regularly communicate with the child. There are provisions that say if a child can't understand or would be adversely impacted by certain information, the attorney can consider that, or they might behave, have an out. Like this example they give in the comment is a lawyer might withhold a psychiatric diagnosis of a client if the psychiatrist said that could create a risk of harm. So there is some ability for the lawyer to screen some information if it would be damaging to their client, their child. Moving on to Rule 1.6, confidentiality. A lawyer shall not reveal information relating to representation of a client unless the client consents. And that is different than the guardian ad litem standard. The guardian ad litem is supposed to report what they know to the court. I think it's important when you look at Rule 1.6 and you consider the Child in Need of Care Code that 38-2209 sets out a number of provisions that actually create a misdemeanor if you share confidential information. So an attorney practicing in the Child in Need of Care Code has to practice within practice standards in addition to maintain those confidentiality rules. There's provisions for conflict of interest, and then we get into Rule 1.14, diminished capacity. When a child's capacity to make adequately considered decisions in connection with the representation is diminished because of minority, the attorney shall try to maintain a normal client-lawyer relationship. And then the rest of the section, Rule 1.14, goes into, but how does that work? And I won't get into it too much. I just want you to be aware that it's there. There are rules that lawyers consult with every day in their practices for how you might deal with a child or any client who has a diminished capacity. And it's not a black or white issue. It might be diminished capacity here, but not diminished here. My child cannot yet figure out when she should turn left at a stoplight, but she can do a number of other things with full competence. And so the diminished capacity rules are very, very client-specific and situation-specific. What I wanted to, and then finally, I did mention Rule 3.3, candor towards the tribunal. Lawyers are supposed to tell the truth to the judge. So being a guardian ad litem or being an attorney wouldn't change that obligation. You wouldn't be able to take a falsehood from your child client and pass it on to the judge. I laid this out because when I first heard of this concept that their hearing is about today, about guardian ad litems who are attorneys versus guardian ad litems who are representing the best interests of the child, I thought, well, there's got to be a lot of differences. What will be all of those differences? And so me being me, I had to go back and find them all. And what I've really discovered as I lined out these two standards side by side is that the duties of an attorney as an attorney and the duties of an attorney as a guardian ad litem are largely consistent. You need to know your case, you need to prepare for court, you need to communicate with your client, you need to present the client's interests. The question in Kansas is, do we want attorneys to be representing the client's, the child's stated wishes as an important part of the case, or whether we want the client and the child's stated wishes to sort of stay behind the scenes as an afterthought while the attorney advocates for what they want for the child, what they think is best. So I want to point out we have worked with really great guardian ad litems over the years. And guardian ad litems can be very, very diligent, and we have seen the best success when guardian ad litems or district attorneys are very, very diligent, doing all the things that you would want to see. In my personal opinion, I think there could be some benefits to considering changing the standard. And that's partly because, and you'll see in my testimony, the National Association of Counsel for Children and other national attorney advocacy groups have moved towards more youth engagement. So probably I was thinking back, it's probably for the last 7 or 8 years, every time I go to a conference, every time I go to a training, a new development is youth engagement, youth voice. Young people who have aged out of foster care or older youth in foster care are saying, listen to us. We matter, our voices matter. And so I've heard story after story, whether at a conference or in individual conversations with young people, that say we need more voice in our care. And I think we should consider that. And I think there's some very specific reasons. One is if a client, if you're, and I have to say this because I'm kind of competitive in the courtroom. Like attorneys, we are a little bit competitive. We want to win. And so if I want to win and I have my perspective, I'm going to get the evidence from my perspective. I'm not going to go ask the questions from the other perspective. But if I'm representing my child client and I want to win, I'm asking the child different questions that matter to the child. And the evidence that might come out in court might be very different if an attorney is sitting down and talking to the child about how do we gather the evidence to help support your wishes and your concerns in a case. Secondly, imagine being a child in foster care and literally no one is being your voice. They're not required to, and it's not a criticism of the different roles that everyone plays. Case managers are working reintegration with parents, and then they're working on adoption. We've heard conflicts that happens in these convoluted situations. But I just think about being heard, the value of being heard as a youth, and going into court and thinking, nothing I say is going to make any difference about everything in my life. And I think it's important that we and I don't usually come in here with emotional testimony because that's not usually how my brain works. But I think in this instance, what is the impact on a child who doesn't have a voice? Maybe they have a protector, but they don't have that voice or making the arguments for them. I think attorneys, an attorney model might encourage a child to appear before them and participate in court proceedings, and it doesn't always happen right now because you can't do your job as an attorney if you don't consult with your client, you don't see them and engage with them. We have the conflict of interest statutes or rules related to attorneys might be more closely looked at related to siblings. And we know that there are sibling situations where different siblings have different interests, and that can be important. We also know that there are some concerns about the idea of an attorney model, and I want to just briefly touch base on those. I think change is hard for anyone. And I particularly don't like when anyone asks me to change when I didn't invite it. That's just, I think you're all not surprised to hear that. But we know there are other states using an attorney model, and the sky has not fallen for them. We know that there are going to be sticky ethical issues with the Code of Professional Responsibility versus how things have always been done that might give attorneys pause or concern about moving to this model. And we know that an attorney model won't solve something we have today in Kansas, which is an attorney and guardian ad litem shortage and heavy workloads. I don't think that the question of this would be asking Kansas to solve the workforce shortage by this model, but it is just something that is a concern. And there is, I think, some question about costs. If attorneys are doing more engagement, more communication, having more lengthy conversations with their judges, is that going to cost more? And I would ask this committee, is it worth the cost for the child to have the voice? Personally, as I've mentioned, I think children in foster care, and I have to say that there's one conversation I've had with a young person, and I told her I would keep her story confidential, but we talked about why running, why repeat running behavior, why repeat juvenile delinquency activity, why she didn't share what she really thought with her case manager about her future. And the answer was nobody was listening to me. There was nowhere for me to go. And so instead of working through the process that we'd like to see, just going to court and advocating for your case and getting what you want, children can begin to act out and put themselves in danger because they begin to be hopeless.
Rachel, we're going to have to ask you to wrap it up, please.
And I am happy to wrap it up because I'm at the end of my testimony.
Very good.
So I'm happy to stand for questions.
We're going to hold off on your questions, and we have a second person, Darcy Olson from Center for the Rights of Abused Children, and is on WebEx. Am I correct? Hopefully? No? We're looking. While we're trying to get a hold of Darcy, do you have any questions for Rachel real quick? Yes, Representative Neighbor.
Thank you, Mr. Chair. Rachel, wouldn't it, and maybe this is just the common sense approach, but wouldn't you think it would work better if that relationship between the lawyer and the client was a positive one or guardian ad litem so that they felt like their voice was being heard? Now, I'm sure there are times that they can ask for.
Sorry?
Yes, we can hear you. Hold on just one moment.
I'm sure there are times when maybe they have an idea that is probably not the best thing for them. But if they want to be heard and they feel like they're being heard, they're not going to run away. They're not going to do defiant things to get attention. How would you answer that?
Representative, I think that you've heard what my position or argument would be is that a child knowing that someone is there to protect them is maybe not for that child the need that they have to have a voice in their own lives. And having a voice in your own life, think about how powerful that has been for you in your own experiences. Without it, I just don't know how kids can keep hope.
I think the gentleman from the Boys and Girls Club today spoke highly of what it was like to be heard and to have a voice and to be able for people to listen to him and how that had evolved and made him who he was today. And I think that was a perfect example leading into this.
And a tough act to follow in testimony. He was great.
Thank you so much. All right, Darcy, I hope you're still there. We'd like to welcome you to the Child Welfare and Foster Care Committee. And thanks for being so patient. Go ahead. Can you hear me now?
Today. I know time is short, so I'm going to cut right to the chase on this important issue. I'm often asked, what if there was one thing we could do for foster kids to make their lives better? What would that change be? It's what before you, it's the right to counsel. It's having that advocacy and that person in the courtroom for them is really what makes all of the other great laws that you've passed for kids either work or not work in their favor. 10 years ago, I became a foster parent and to the drug-exposed newborn babies, and I expected a lot of what I faced, the convulsions, the late nights, and all of those things. But what I didn't expect was that in this system, I would have to hire an attorney to protect the rights of those children. And I'd like to tell you that the legal system takes every effort and measure to protect these children, that their focus is on the children's rights to life and to safety. But it's not the case for kids in my home state of Arizona, in Kansas, or the vast majority of the states across country. All of the other parties in these abuse and abandonment proceedings are provided counsel. The biological parents have counsel before the first court hearing. The agencies have counsel. The only people who don't have equal representation in counsel are the abuse victims themselves. We do recognize that in Kansas that you've got guardian ad litems for children, and that's some measure of protection. But a guardian's duty is to the court, and it is a big reason that what you're hearing is sometimes the guardian ad litems work well for kids and sometimes they don't. They are working advisors. They are not lawyers for the children. There's no attorney-client privilege, and there is no obligation for the zealous legal advocacy that the legal profession must abide by in all other instances. And most important, the facts on this speak for themselves. Children with attorneys versus a guardian ad litem or no attorneys exit the system up to 3 times faster than kids without that representation. And that's a goal we all agree on. We want them to either be able to go home or to go to some other kind of permanency. Legal representation simply affords the best means of protecting children's fundamental rights. And there's not one person in this hearing room today who would accept less for their own children. And we should not accept less for these children in foster care who have already been damaged and hurt. If anything, they need more, not less. I'm happy to take any questions that I can hear through the Zoom.
Thank you so much. Do we have questions from the committee? I just have a question then. The cost of having their own attorney, how is that normally taken care of? Is that a state required payment?
Our proposal is that you, instead of the guardian ad litems being the mandatory appointment in Kansas, that the mandatory appointment becomes counsel. So you would use that same funding stream. There are also federal matching funds available under Title 4E, which come into play in these situations. And then we've also provided an appendix. There are a lot of grants and federal monies available, especially in rural areas, that could actually bring in more money to the state than you're currently drawing down.
Thank you. Yes, Representative Humphreys.
Thank you. Thank you for being with us. So if I understand, this started in Arizona a few years ago. Is that correct?
That's correct.
Yep.
It's good to hear your familiar voice.
Nice to see you too. Thank you. And can you just tell us a little bit more about what the results have been in Arizona so far?
So we put this into place 2 years ago. So we don't have hard data yet, but we run a pro bono law clinic for abused and abandoned children in our state. It's the only one of its kind. So we see a lot of different types of cases. And so far, working very well. We've had very few people come in to say that the attorneys aren't working well. We've had the opposite. So we've been able to pivot and help older kids. Sometimes the judges in very complicated situations will also appoint a guardian ad litem. They certainly have the discretion to do so, but the judges are telling us that they're not feeling the need to do that because counsel is doing a great job. I do have just one point on that I'd like to make that came up in the last time we all met, and that is that from the Department of Health and Human Services, their point of view is that the appointment of an attorney alone is consistent with CAFTA requirements because advocating the child's wishes and preferences could be seen as the child's best interests, serving the child's best interests, and helping the courts to better arrive at overall decisions that are best for the child. And that is, in fact, what we are seeing. And that's what the national organizations, the National Council of Juvenile and Family Court Judges is saying, the Conference of State Court Administrators, the ABA, as well as the Administration on Children and Families.
Great. Thank you so much. Thanks. That's helpful.
Yes, Representative Lewis.
Thank you, Mr. Vice Chair. Rachel, this is Bob Lewis, Representative Lewis. I was I'm on the Judiciary Committee, and you testified there about this issue. And after your testimony, I went back to my hometown of Garden City, and I was talking to several CASA representatives, and I asked them, about the guardian ad litem situation. And I said to them, can you tell me just from your own experience, how often it is that the guardian ad litems actually talk to the child? And I can't say this was a scientific survey, this is just anecdotal, but the 2 or 3 I talked to all said virtually never. And I'm just wondering from your own experience, what you know about that. How often the guardian ad litems actually talk to and consider seriously the wishes, if you would, of the child.
That question was for me or for Rachel?
I'm sorry, I misspoke about, your name is not
Darcy.
Rachel, Darcy. It was intended for Darcy, because Darcy, you're the one that testified. I apologize.
Okay, I'm sorry because I can't see anyone in the room. So it unfortunately cut out a bit during your question, and I know it has to do with CASAs and what a few people have said to you, but I couldn't get the question.
If I might, I'll try and truncate it and just say, in your experience, how often is it that the guardian ad litem does not speak to the child, him or herself? Is that frequent or not?
Well, so in our experience in our state, that was a frequent problem where the guardian ad litems were not even meeting with the children. They would send out a social worker. I'm not on the ground in Kansas, but reading your newspaper reports and talking to folks there, we do hear that is a problem. We also hear that you have some incredible guardian ad litems. One of the reasons we like the right to counsel is that practicing attorneys they practice under very strict ethical standards. So we would not expect to see quite the variation that we're seeing right now with the guardian ad litem program.
Thank you.
I have time for one more question. Representative Howerton.
Thank you, Mr. Vice Chair. I was just wondering, along the same lines as Representative Lewis, is there a study out there that shows the effectiveness of guardian ad litems? And maybe that's something research could check into. My experience with guardian ad litems in the few cases that I've been involved with or have witnessed is that they do not talk to the children here in Kansas. And so I'm very interested in this change. So thank you.
Thank you so much for that question. There are 2 really comprehensive reports on this, and I believe that John Monroe, who's there in person, or Kendall Seal would be able to get those over to you. And I know they're footnoted, but I'm sorry, I can't recall exactly where.
Thank you so much. I am going to go ahead and stop questions. I want to thank Rachel and Darcy, especially for your patience in coming in. If you would like to get some more information, he'll be here. As for me, I'm going to go to the bathroom. I would now entertain a motion for the minutes of approval on March 15th. You had a chance to have a motion. Do I have a second? I have a second from Representative Neighbor. All in favor say aye. All opposed say no. Motion passes. And thank you, everyone, and we are adjourned.